Вітаємо вас, пане Романе.
Good morning, Roman. Good morning.
Починаємо співбесіду.
We are starting your interview, which will be conducted by the following commissioners: Yevhen Mezentsev, Ivan Mishchenko, Robert Brugheisen, Ted Zazhechny, and Stephen Markman. Sergei Verlanov has announced self-recusal because, as far as I understand, you're working at the same court. Should for any reasons your interview be interrupted, we will reach you and reschedule it for a different time and different day. Should anything like that happen. The commissioners are going to be asking you questions, and we are kindly asking you to be precise in your answers. The interview will start with your introductory remarks. You will be given up to 5 minutes to tell us about your motivation to participate in the selection, to tell us why you should be the one appointed, to tell us more about your ideas about the development of the judiciary and the HQCJ in particular. With that, I'm passing the floor to Yevhen and Robert. Thank you, Ivan. Good morning, Roman. I hope everything is okay with you. My name is Yevhen Mezentsev, and today I'm going to be the lead rapporteur for your interview. My co-rapporteur is Robert Brugheisen. So I would like to make a short introduction for our commissioners and for the audience, drawing attention to your autobiography. So you were born in 1970. You are a judge of the Kyiv Appellate Court. You have the total experience of 25 years working in the field of law. You've been a judge for 17 years. You started getting your degree at Saratov State Institute. Before 2014, you were working in courts of Luhansk region. Then you transferred to Kyiv Appellate Court. In 2016, you completed qualification assessment at the HQCJ. As far as your language proficiency is concerned, you have provided us with a relevant certificate. It should be noted that you have a big number of dissenting opinions. For instance, those dissenting opinions dealt with judge investigators and the Grand Chamber of the Supreme Court in the result supported the opinion expressed by you. As far as property status is concerned, you have 2 apartments with the area of 47 and 63 square meters in the city of Luhansk. You also declared 2 apartments in the city of Kyiv, mentioning it was temporary accommodation, and now you have a corporate apartment in the city of Kyiv. In your most recent declaration, you declared an income of 2.5 million hryvnias. As far as property status is concerned and the NABU certificate, the NABU has no concerns, but there are some questions with regards to declaration of the Karhaval H9, but we will go back to that a little bit later throughout our interview. So practically, this is the main information from your autobiography. With that, I'm passing the floor to you, Roman, for your introductory remarks. You're welcome. Thank you for this opportunity. My name is Roman Ihnatov. I've been working in criminal justice for more than 25 years. I've been a judge for more than 19 years already. Before that, I worked as a prosecutor with the prosecutor's office. In 1995, I graduated from Saratov Law Academy, and we had a different curriculum there, different from the Kharkiv Law Academy. So we had exams in autumn, and in summer I had internship at prosecutor's office in Russia, in Petrozavodsk. I was senior investigator. Based on the result of my internship, I was offered a position at the prosecutor's office of the city of Petrozavodsk on condition that I did not have Ukrainian citizenship, and I did not have any citizenship until 1997, and I have provided relevant documents about this fact. On graduation from the academy, starting from November the 1st, I was already working as a senior investigator at the prosecutor's office of Petrozavodsk. It should be mentioned that I never had Russian citizenship. I never applied for Russian citizenship. And it was checked on a number of occasions, at least twice. It was first checked in July of 2001 when I was transferred from the position of senior investigator in Stanично-Luhansk district to the prosecutor's office of Luhansk region, to specialized department overseeing pretrial investigation. In order to be admitted to work within law enforcement bodies, according to the decree of the Prosecutors General of Ukraine, every employee of the prosecutor's office had to complete a special check, had to undergo a special check, and there were no concerns with regards to my potential Russian citizenship expressed. And when I came back home to Luhansk region, I requested an official document from the Migration Service of Russian Federation, which said that during my stay on the territory of the Russian Federation, I have never applied for Russian citizenship, and I've never had Russian citizenship. At the time when I was staying on the territory of Russian Federation, I had the passport of the citizen of Soviet Union. So you may remember that Ukrainian citizens got a stamp in their passport, while Russian citizens got some kind of additional pages. But until July of 1997, I was a person with no citizenship. And then when I returned to the city of Luhansk, when I started working there, there were family reasons which I have explained in my explanations. I have senior parents. My father was born in 1931 and my mother was born in 1934. So they started complaining that I was far from home, and my father had a disability. He had bronchial asthma. He later got cancer, and that was the cause of his death. So I was provided with a reference from the prosecutor of Petrozavodsk, and you can find this reference in the dossier of the prosecutor's office of Luhansk region. Yes, of course, I took that document from the Federal Migration Service, which also includes this information. Plus, there are some inconsistencies in the questions saying that I got Ukrainian citizenship in 1997. No, I got Ukrainian citizenship in 1996 by having a stamp which, following the law of Ukraine of 1991, which foresees that after the collapse of the Soviet Union, no, I did not apply for any other citizenship other than the citizenship of Ukraine. That's why I got a passport a stamp made in my passport according to Form 1, and I provided this proof during the first time that I was undergoing a special check, and the second time I provided these documents when I was asked specific documents. So please pay your attention that in section 6 of Form 1, it says that I resided in the city of Luhansk, and answering the question, have you ever had any other citizenship than citizenship of Ukraine? And I answered no. And my Soviet Union passport was replaced with the Ukrainian passport in 1997. You may remember that the new type of Ukrainian passport, the number of those passports were insufficient in police departments to be provided to all of the citizens who wanted to get them. So I'm going to be citing the confirming documents that my Ukrainian citizenship was confirmed in 1996. And I would also like to draw your attention to my employment record book, page 10, where it states that starting from July the 1st of 1996, I was the investigator at the prosecutor's office in Luhansk region. Then I was the senior investigator at Stanitsa Luhanska prosecutor's office. And then I was transferred to the prosecutor's office of Luhansk region. As I already mentioned, I worked at the department overseeing the pre-trial investigation, and there I was part of a special check, which I needed to be a part of to be admitted to my position. And after that, I was appointed for my position, which was one of the top positions in the prosecutor's office. I was a deputy prosecutor of the city of Bryanka. It's a big city with 2 mines, 2 factories making equipment for mines. I'm sorry, Roman, sorry for interrupting you. Let us not focus on your career this much. Your explanations with regards to Ukrainian citizenship, that was one of the questions that we wanted to ask you. You have already explained the case. It's quite a typical situation for people who first got a Soviet passport, who got their degree during the collapse of the Soviet Union, and who later had some issues with getting documents. So you're not the only one having such problems. But let's go back to your motivation. Why have you decided to apply for this selection? What motivated you? And how do you see your own role in the development of this judicial body? Thank you. My motivation is as follows. I'm a person of integrity, which has been also confirmed by civil society organizations, including Chesno. I will be able to say no when everybody else says yes, and this is proven by my work as a judge of the appellate court. When I was part of criminal proceedings, I was the only judge of the criminal chamber of Kyiv Appellate Court who had a different opinion, who expressed a dissent. Psychologically, it's very difficult to have an opinion that differs from the opinion of others when your name is mentioned in negative light. But it was my belief, it was my position, which was later confirmed by the decision of the Supreme Court. And there was the final confirmation by the Grand Chamber of the Supreme Court. If you ask me about the role of HQCJ, should I be appointed as its member, I would pay more attention to the professional competencies of judges during their assessment. I'm not sure that the testing that everybody is now discussing is the most efficient way to assess professional competencies of a judge, because I believe that as a result we are getting mechanical answers. Namely, when we are having interviews with candidates, a person examining them can assess their logical thinking, their knowledge of the legislation, and not just automatically score their tests when there are a number of answers, when you have multiple choice questions. Plus, we also need to fill the vacancies for local and appellate courts to create the conditions for the work of judges and give them time for their training, because our legislation is constantly changing, so that we have a uniformed approach towards the application of legislation. We very often work within panels and we don't have time to review the recent amendments to criminal legislation or study the decisions of the European Court for Human Rights. It should also be mentioned that in the case of Bantesh versus Ukraine, which practically is identical to the decision Karelian versus Ukraine. So these cases tell us how important administrative cases are. The punishment in this type of cases, and according to the decisions of the European Court for Human Rights, these cases are equal to criminal cases. This category of cases takes the fourth place. I've been monitoring it. Of course, the first place is taken by the enforcement of national courts. Number 2, violation of Article 5. Number 3, violation of Article 6. And number 4 are decisions in cases on administrative violations. Thank you. Thank you, Roman. Let us discuss your purchase of the car. In 2010, you bought a Ssangyong car, a new one, for approximately $26,000, and in 2013, you bought a Chevrolet car for $34,000. As far as the Chevrolet is concerned, we've received explanation about the sources of income used to buy the car, including credit money, savings. And now, with regards to Ssangyong, could you please explain that? I understand that it happened 13 years ago, but what was the source of income that you used to buy the car? Thank you for this question. I can give you a very detailed explanation. Okay, maybe let's not be too detailed. Try to use a minute or a minute and a half. So in 1994, my father gifted me 61 acres of land. Then in 2010, I sold the property. It wasn't a land plot. It was a small house, sorry. And I sold it for 116,000 hryvnias. I have provided you with the official sale and purchase agreement with the explanation. And I then added the savings. And then I went to OTP Bank and took out a loan. So that is the credit money that I used, and I paid it off within 3 years, a little bit over than 3 years. So I was a VIP client, as I was called at that moment, because I made my payments in time and I paid it off prematurely. So I got a share of the money after selling that small house that was given to me by my father. And this is all confirmed by documents. There are all the sale and purchase agreements that I have provided you with. In 2021, you also bought a car, Haval, or Haval, I don't know how to pronounce the make correctly, Haval H9. So you bought it from a car salon, so it was a new car. It's not about the source of money because your income was sufficient enough to make this kind of purchase. But NABU has questions that while filling Section 6 of your declaration, you did not mention this car in Section 14 with regards to agreements. I'm sorry, but this is a mistake on the part of NABU. I mentioned the car in Section 4. I have provided you with the document, Section 4, real estate and cars, and I mentioned it in Section 9, expenses. I can even find this document and show it to you. Thank you. There's also this question that we need to discuss with you with regards to your wife. Your wife, in 2014, reported on your unlawful imprisonment. Yes, could you please tell us a little bit about this? Yes, it did happen. I was not imprisoned, but I was taken hostage by the so-called representatives of Luhansk's People's Republic. And luckily, we have a witness because I was offered to support Russia, to support the so-called People's Republic. And I was very harsh when talking to the representatives of the so-called People's Republic. And towards the end of our conversation, I told them that I didn't want to be a traitor. And there was another judge sitting beside me who was also taken hostage, Vitaly Lukyanchuk, and he's currently working at the Cherkasy appellate court. He used to work in Severodonetsk. So the circumstances are the following. On November the 10th of 2014, after I was reading the official decrees and understanding that when I was going to start my work as a Kyiv appellate court judge, I realized that I would not be able to go back to Luhansk to see my mother, and my mother was old, so I decided to travel to Luhansk. It should be mentioned that at the time there were no prohibitions on the part of the Security Service of Ukraine, nor the Council of Judges of Ukraine. Plus, some of the judges still lived on the occupied territories and traveled to Severodonetsk for the meetings of the Congress of Judges. So, when I traveled to Luhansk, I met Vitaly Lukyanchuk there, my colleague, and we were taken hostage. And I later discovered that we were taken hostage by representatives of the so-called military men from the Luhansk People's Republic. There were 4 of them. 3 of them were tall, and 1 of them was quite short. And the short man was their commander. They had the red insignia with a yellow letter K. The reason for that was that I went back to my office to take some of my belongings, and there was the map of Ukraine gifted to me by my wife and 2 books, which I considered to be quite valuable. But actually, they took us hostage because we were called judges from the other side. We were informed that we were arrested, And then the three soldiers who were holding machine guns pointed them at us, and the commander only had a gun, so they pointed their weapons at us. Then we were escorted to two minivans, the minivans of the color khaki, and then we were brought to Lenin District Police Department, and I'm well aware where that police department is. So we were searched. They took away our mobile phones, and then we were transferred to the so-called militia of the Luhansk People's Republic. And then we were arrested and put into a prison cell. And Vitaly Lukyanchuk, he is much younger than I am. He's 10 years younger. He's never worked at law enforcement, and he became very confused when he was put inside a prison cell. And they did it on purpose. We were put together into a prison cell with prisoners, with actual prisoners and criminals. I know how to talk to people like that. I know how to talk to criminals because I used to be an investigator. I had to travel to different penitentiaries in Luhansk region, so I did have the experience of talking to inmates. I knew what kind of composure you needed to have. So let's not discuss that, yes. So it helped us that I had that experience. And then we were asked where the judges were, and the answer was prison cell number 1. And one of the inmates was really surprised that they imprisoned judges. That's clear. That's clear. The circumstances are indeed tragic. Let's not go into further detail. Could you please tell us, is there any pressure exerted upon you via your family members? I mean those family members who are staying on the occupied territories, if there are any relatives staying there. Unfortunately, there are no relatives left there. My mother died in 2017, and my father died in 2010, as I've already mentioned. And my aunt, the aunt who gifted me the one-bedroom apartment, she died in 2012, so I don't have any relatives left in Luhansk. Thank you. I'm passing the floor to Robert, to my colleague.
Yes, good morning.
Good morning.
This is, of course, a terrible story that you just told us. This also may have influenced your views on being a judge and on justice, or because you have been very badly treated. What can you say about that?
Well, I'm a judge, yes. Yes, I want to be a judge, and I've been a judge, and the main motive, when I was taken hostage, that's what I told to that Russian officer, that I didn't want to live like a person who's a traitor. And Vitaly Fedorovich heard that, and he started scolding me that I was using the wrong language, because after me saying that I didn't want to be a traitor, they could really execute us, because they shot people down, or they shot their knees. They shot them in the knees. Yes, indeed, I'm a judge, and I took oaths twice. throughout my life. For the first time when I was serving in the Soviet army, and my second oath was the oath of a judge. The word oath is not an empty word for me. So when I was working at the law enforcement, we didn't have the Institute of Oath as yet. I first took my oath when I was appointed as a judge. An oath is not just an empty word.
It is certainly not an empty word. In your motivation letter, you say, I see the judiciary of Ukraine in the future as completely depoliticized. What's the English word? How you pronounce this? Depoliticized?
Hypothesized?
No,
Depoliticized.
say it again.
Depoliticized.
Depoliticized. I'm sorry about it. It's a difficult word. I will repeat it. I see the judiciary of Ukraine in the future as completely depoliticized and accountable to the society, with courts being really staffed with competent judges with integrity. That's what you say. I'm interested in the word depoliticized. It suggests that at present the courts are not depoliticized. Can you explain, because you also say in your motivation letter that you know about the problems of courts and judicial bodies from the inside. Can you explain to me what this depoliticization means for you? And what can be done to take this influence of politics out of the judiciary?
Дякую вам за запитання. Я можу пояснити наступне.
Thank you for the question. So let me explain the following. The judiciary reform was launched in 1992, in fact, on the 28th of April, when the resolution of the Verkhovna Rada approved the first concept of the reform of the judiciary. And the objective was to rebuild the judiciary and to create an independent judiciary. Unfortunately, the process is still going on, and every new president keeps coming and starting the judiciary reform anew. After Mr. Poroshenko's term of office finished, he said that he had completed the judicial reform, but now we have a new stage of the reform. I'm convinced that, unfortunately, our authorities are not that much interested in having the independent judiciary. But anyway, I'm sure that without the will of the top political officials, there will be no independent judiciary in Ukraine. And let me give you an example of Romania here. Recently, it has been mentioned as far as successful fighting of corruption is concerned. And there has been an interview of the anti-corruption prosecutor of the so-called DNA of Romania in Ukrainska Pravda. And the prosecutor mentioned 3 basic rules that should be kept and complied with by the state for it to have a good result. First of all, this is the will of the top political authorities and their willingness to fight corruption. Also, stable anti-corruption legislation that will not be changing depending on the circumstances and depending on the people involved. And also, stable work of the representatives of those bodies, of the staff. They should be afraid that tomorrow they are dismissed for the decision that you have passed, that they will be dismissed because they have taken some investigative actions or made some investigations in relation to some person. This is just the so-called input data. I understand what the current terms in Ukraine are, what the current reality is. But anyway, we need to fight corruption and to fight a lot of other things. And a lot also depends on the HQCJ and the High Council of Justice. That's why these bodies are established, for them to work in this direction and to somehow influence the situation legally.
Thank you, Mr. Ihnatov. I would appreciate if you, and I know that this is maybe not in accordance with Ukrainian habit, to answer the question as short as you can, because then otherwise we cannot discuss all the issues that we would like to discuss with you. you have to understand that I'm looking. That's why I've been busy. We have been busy now for more than 1 week in interviews, and that for someone from the Netherlands, it's quite an adventure to see all the judges explaining about corruption and what should be done about it. And there are two things that I see. The first thing I see is that the judiciary finds it very difficult to discuss that corruption exists inside of the judiciary. That's the first thing that I see. And the second thing that I see is that that judiciary is built in such a way with self-regulation and etc. that it says it will solve its own problems. And sometimes I don't see the judiciary solve its own problems, so it has to have help from the outside. What's your view on that?
Well, first of all, I have never held any administrative positions in courts. This is my first competition in this direction, so I can only say one thing, that de jure, we really have self-government, judicial self-government, but unfortunately, if we speak about integrity, and integrity, actually in Ukrainian, it's a play on words, consists of two parts. It's like the good and goodness and honesty. So sometimes, really, there may be some pressure exerted on judges, and this is not the case in many civilized countries that we take as an example. It is the judiciary and court that are called to be the tool that complies with the principles of checks and balances. And let me quote one statement which is rather important. This is the citation of the American congressman of the 19th century, lawyer Alexander Hamilton, who mentioned that the judiciary is the least dangerous, the judicial branch of power is the least dangerous as compared to the two other branches, because executive power has some tools like fiscal bodies, and the legislative authorities can also manipulate the budget assignments, and so on and so forth. And the judiciary doesn't have any tools and levels like that. It just has the authority and the reputation of court decisions. But the reputation and the authority of court decisions depends on the quality of national legislation, and the European Court of Human Rights has pointed it many a time. And there is the report of 2011 approved by the Venice Commission, which says in Section 4 that there are 6 ingredients, 6 components of the rule of law. And
we know about the rule of law. Of course we do, and I did only ask about your own experience and not the rules and regulation, because of course we are aware of that. But I will pass the floor to my colleague, Justice Markman.
Thank you very much. Judge Ihnatov, thank you for your participation in this competition. I do have a few questions. Of course, everything that you said about your detention rings very, very true. Who can doubt that that no one would want to be a traitor in the situation that you were offered? But let me ask you to think about a slightly or a very much different situation. This is hypothetical. But let's say you were confronted with a decision. Judge Ihnatov, you can become a judge of Ukraine, or you can become a judge of Russia. Either decision will be respected. You won't be a traitor, you won't be viewed badly, but you can go become a jurist in this country, or you can become a jurist in that country. And you'll have different responsibilities because they're two different countries. What would be the different responsibilities as a judge you would understand that you would be exercising and carrying out if you were a judge in one country as opposed to the other country here, Russia or Ukraine? Can you characterize how your responsibilities would be distinguished and how your role would be different and how you would interact with the executive. You talk about Hamilton, how you would interact with the executive in the legislative branches of government differently. Could you give us some perspective on that from your viewpoint?
Дякую за запитання.
Thank you for the question. Well, first of all, let me mention that I have already made my choice. I did this when I was in captivity because I was given this offer to become a judge. At first, I should have become a member of the law enforcement bodies, but then I could become a judge. But I've made my choice. I am the judge of Ukraine, and I will remain the judge of Ukraine until the end of my career. As far as the judiciary of Russia is concerned.
Sir, my question is an academic question. I know you've made your decision, and I know you'll be a Ukrainian judge for the rest of your life or whatever else you pursue. But I'm just asking an academic question, trying to understand what are the differences between being a judge in these two countries.
Для того, щоб знати про відмінність,
Well, to know about the differences, I would actually need to at least get acquainted with the judiciary of Russia or to work there. I don't know anything about the details, about the nuances. I cannot actually give the answer because I've worked for more than 25 years in Ukraine only.
я тільки на практиці проходив в судах Росії. Коли була у нас практика.
We had some internship when I was a third year student, and I had something to deal with Russian courts, but generally I don't know anything of that. But as I know from open sources, well, the system in Russia is different. They don't have acquittals, and they also close such issues at the so-called the stage of the so-called pre-trial investigation. That's what I know from the open sources, but I don't know anything about the details of functioning and about the commitments of judges and functions of judges and the responsibilities in Russia. I'm not interested in this, I'm interested in the issues of the European Court. I've just returned from the workshop on war crimes, and have been assigned the status of trainer on crimes against humanity. This is related to war crimes, to the genocide. And I went to the conference in Warsaw. I stayed there for 4 days, and the conference finished on the 22nd of January. And we were given some trainings by the incumbent judges of the International Tribunal in Hague. That's why I cannot actually cover the situation of the responsibility of judges in Russia.
Okay, maybe that was a difficult question to ask. But let me ask you about the case in which you indicated you wrote 12 dissents. I think that does provide some indication of your independence, and I respect that decision. This had to do with appeals of investigative judges' rulings. I don't know the details, but that also sounds like a good decision to me. But I really don't know if it's a good decision or not because I don't know what the law of Ukraine said. And that to me is what's all important. Sometimes there's good ideas in the law and sometimes there's bad ideas in the law. At least I might view them that way, but it's my job as a judge to abide by the law of Ukraine. What was the law in that case? Were you were on the side of the law, you believe, is that correct? Not just doing a good thing, but you believe you were on the side of the law in that case, even though in all those cases you dissented, correct?
Thank you for the question. Yes, that's true. As far as the first part of your question is concerned, all the resolutions on the so-called irregular inspections within criminal cases were passed by the investigative judges beyond the criminal code, which means that they were not envisaged by the criminal code of Ukraine at all, by the criminal procedure code. And the appellate instances actually deprived the trial participants and other people to whom these resolutions were related of the right to appeal. And that was an unprecedented fact that cannot be allowed, that cannot be accepted when the investigative judge purposefully goes beyond the limits of the commitments, and then that's why I acted in that way.
In the
Крім того, у
Supreme
мене
Court.
були також
Besides that, I also had some other high-profile cases when people,
дуже гучній справі. Це було
well, that was a murder of an attorney at law, Mr. Ihnatov, and now I can tell the name because these people have been recognized at the trial court to be guilty, and they've been sentenced. So for more than 4 months, these people were under detention on an illegal basis. And the judge who was hearing this case of detention, and one judge is allowed to do this. So she she announced self-recusal, but she continued keeping those people in custody.
Well, let me move on.
And of course, we had to react to that.
Yeah, I'm sure there's other cases which you indicated your independence, but I think the investigative case was a good illustration of that tendency on your part, and I just wanted to see if you felt you were also on the side of the law and not just showing your independence. And you say you feel you were also on the side of the law in that case, correct?
Sure. It was only within the law. The law is the main regulator of societal relationship in this country, which belongs to the continental law, Roman-Germanic system of law. It's only the law that the main regulator, the constitution, and the international treaties ratified by Ukraine.
And when you mention Hamilton, I think of what he said in the Federalist Papers. He not only said that judges are limited in terms of exercising their authority and their persuasive abilities, but that they are within the scope of their authority when they act within the law. If they go outside the law and say, we think this is a better idea than what the law says, they don't have the same degree of authority. So I think it's an apt quote that you have from Alexander Hamilton, but I remind you that he also spoke about acting within the authority of the law, of course. Judge Ihnatov, we have to recommend 16 judges, and there will be 8 judges on the High Qualifications Commission, and I expect all these will be people who are experienced, who are learned in the law, who understand the rule of law, who are persons of integrity and committed to reform. If we select you, what do you have to add to that? What is your strength? What distinguishes you from all other good judges? I assume you will have the experience, you will have all these other attributes, but what will be the basis on which we should choose you from all the other judges, good judges who are in this competition?
Well, thank you for the question. If I try to characterize me from the point of view of my strengths, I could say that I'm a man of principle. I always advocate my point of view if it corresponds to the law, and I also lend an attentive ear to the opinions of my colleagues if the colleague is really not interpreting the law, going beyond the law, but is keeping to the law or referring to the law. And my main characteristics is my principled matter. I'm a man of principle, a judge of principle.
And you think that would be a distinguishing quality of yours?
Well, it's important for a judge to be a man of principle. It's not a little. A judge must be a man of principle. He should be steady. He should comply with the law only. He should not be looking at some trends, at some winds flowing in going in certain directions. No, he should be complying with the law. Actually, the judge is the slave of the law in a way, of the national law, because in the Anglo-Saxon system of law, it's different. In our system, the rules are different, but the law is the law. It's not important what we call it. Is it the court precedent or a regulatory act? But that's the law, and we should comply with it.
But if you serve on the High Qualifications Commission, is there an argument to be made that you must balance your independence with being a member of the team?
Well, thank you for the question. Well, of course, I will have to balance my independence with the balance of other members, because the HQCJ is a joint body, and teamwork is an art, I would say. This is the art of listening to other people, not just listening, but hearing your opponents. And that is a real art. And first of all, I can hear a lot of cases in panels, and I wouldn't say that we always are unanimous on this or that issue. But we still hear cases in panels consisting of 3 or 5 judges, depending on the subject. And in the High Qualification Commission, there will be 16 members, out of whom 8 are judges and 8 are other legal professionals, like researchers, attorneys at law. And of course, we will have to be diplomatic as members of the HQCJ. We will have to show our ability to hear others, to ask the right questions concerning motivation and the arguments. Suppose I have some doubts about the standpoint of a set member of the commission, I need to hear the arguments, so I need to ask the right questions. That is the art, let me stress this. It's not easy to work in a team, but this is the art you can gain with experience. And I've got some experience because I've been working in the appellate instance for 10 years, 5 years in the appellate court of Luhansk region, and then almost 5 years in Kyiv appellate court, which means actually more than 10 years. And we hear cases in panels. Only administrative offenses can be considered by one judge. This is my answer.
Okay. Thank you very much, Judge. I'll pass you on to my colleague, Mr. Zarzeczny.
Judge Ihnatov, I want to return, if I may, to your motivation letter, and in particular your answer to question 8, which we have posed to all candidates, dealing with the increase of the level of public trust in judicial institutions. Now, in your letter, you make the following statement: I see the judiciary of Ukraine in the future, and I stress that, in the future, as completely depoliticized. And you were asked a question about this already. Are you suggesting that in the present, the judges are politicized? And if so, have you personal experience with this?
Thank you for the question. I don't think that all judges are politicized in the Ukrainian judiciary now. That depends on every individual judge. And on personal skills of this or that judge. Somebody can know how to say no, but some judges are not brave enough to say no. It's always more difficult to say no than to say yes. That's why I cannot tell that all judges are politicized. I will not undertake a responsibility like that to make such a statement. But there are some features that show the high level of politicization of the Ukrainian judiciary, and that is common knowledge. That's my answer.
Well, and you go on to say, and again, I'll stress, in the future, courts would be staffed with competent judges with integrity. Again, is that not the case in the present?
Well, the situation is also different now. In trial courts, first instance courts, well, let me start it from a different point of view. The situation may be different. For example, I'm concerned and I'm indignant about the fact that sometimes you consider cases of administrative offenses, and in the appellate instance you come to realize that their offender who was acknowledged to be guilty has not even seen a judge any single time. So this situation is unacceptable. That is not the right thing to happen. But I understand what the reasons for that are. These are excessive workload, staff shortage. These are all the problems. These are not excuses. These are just the explanations to this problem. That's my answer.
Yes, and next you say that in the future there will be judges not afraid to take court decisions. And once again, do you have experience with judges who demonstrate fear of taking court decisions presently?
That's the end of air alarm in Kyiv. That's the signal coming. So we keep telling a lot about, speaking a lot about integrity. Integrity, besides other things, stands for the completeness and, of course, for honesty. If I give you a frank answer to your question, I have really experienced such cases when judges are afraid because of their future. They are afraid to pass decisions because they are concerned about their future. And that leads us back to what I started with, that the judicial reform was launched in 1992 on the 28th of April, and it has been going on for more than 30 years. After World War II, states were restored within 30 years, but we are still rebuilding the independent judiciary. So the question arises, if we are still restoring it, building it, so what is the reason for that? Why don't we have a really independent, fully independent judiciary? And again, this leads us back to the issue of personality of judges. A lot of judges know how to say no, but unfortunately there are also judges who choose a different tactics and they say yes. And there is a saying that only a living fish, live fish, can go against the current, while dead fish flows along the current. So it would be good if we didn't have any dead fish in our judiciary, if we had those living fish organisms in our judiciary. The overwhelming majority of them. In my motivational letter, I referred to the expression of one of the emperors of the Roman Empire, saying that the justice is the soil, the ground of a civilized state. I'm not talking about totalitarian states. I'm talking only about civilized states. It is the court that performs this function of exercising control over checks and balances. So that's my answer to the question.
Now, let me tell you why I have raised your motivation letter and what I consider to be some stereotypes that is the perception that some people have with respect to the shortcomings of judges and the changes that need be made. You speak about those changes when you talk about the future. As a member of the High Qualification Commission, as you have applied to be considered to be, you will be an agent of change to accomplish this future vision that you have shared with us respecting the judiciary. Now, the problem is not simply the identification of the goals of the future. The challenge is, how do you accomplish it? So how will you accomplish these changes that you see for the future of the judiciary in your role as a member of the High Qualification Commission of Judges?
Well, first of all, I will act within the functions and the mandate set for me by the law of Ukraine and the judiciary status of judges, because you know that there are, the functions of the HQCJ members determined there. As far as specific changes are concerned, that will depend on the situation I'm facing. But my direction of work and my motivation are still to change something, to reach high professionalism of judges, to complete filling the vacancies, and also a tailored approach to individual responsibility of judges. So a lot of components, and all these components are mentioned in Article 92 and on of the law of Ukraine on the judiciary and the status of judges. And primarily, I'm talking here about compliance with my mandate as that of the member of the HQCJ.
Well, yes. And of course, a good amount of these mandates have also been in place in the past with past High Qualification Commission members. What in the future will you do different as a member of the HQCJ to improve the selection of judges? I can read the law just as you can read the law. The question is, how are you going to apply your roles and responsibilities as a member of the HQCJ to achieve the results that you speak of for the future of judges in Ukraine?
Well, first of all, let me mention that this is joint work, not of one member of the HQCJ, but of the whole commission. That should be the work that is well coordinated. The members should interact with each other and coordinate their activity towards a certain objective. The objective that is, well, in a way limited by the mandate of the members of the HQCJ. Well, if you ask me to tell specifically what I will do, I just have to repeat that I will do whatever is presupposed, whatever is envisaged by the law on the judiciary and status of judges, and the improvements, the changes will depend on a specific situation. But at least I can tell no in the situation when everybody else will say yes, if I see that this does not comply with the law. If something does not comply with the law. If we speak about the situation you have mentioned, I would like to say that a lot of negative resonance has been introduced by mass media, and courts have been, in a way, persecuted or bullied for several years already, for almost 10 years. And I don't think that this has a positive impact on the assessment of the judiciary by the society. And another important thing, as I think, is the quality of the law.
Не одне рішення Європейського суду з прав людини щодо України
Decisions of the European Court of Human Rights concerning Ukraine claim that there is lack of quality of the laws of Ukraine.
All right, thank you very much, Judge. Those are my questions. I will return the matter to our chairman and the chief rapporteur.
Thank you, sir. Прошу, пане голово. Ваші
Mr. Chairman, please, your questions.
Пане Романе, з якістю законів давайте розберемося.
Roman, let us discuss the quality of laws.
Суддя раб закону повинен
So you mentioned that a judge is a slave of the law, and I do agree with you on this one, but you've just said that the European courts draw attention to low quality of our laws.
справа, яку ви згадували.
And even that case that you mentioned in the motivational letter where you were supported by the Supreme Court, but if we don't go into detail, it was about your interpretation of a law that lacked quality, and you were supported in that by the Supreme Court. Hence my question.
З одного боку, ми констатуємо,
On the one hand, we are saying that we have low quality laws,
застосовувати так звану суддівську
which
правотворчість.
makes judges use the so-called judicial lawmaking, yet on the other hand, the judges have their hands tied by the requirements of non-quality laws. So where is this balance? The decision of the European Court for Human Rights in case Chicken versus Ukraine gives us the answer. In case of incompliance of national legislation with the quality criteria, the national judges should be acting in the interest of the defendant. But you mentioned just one case. I'm talking about a number of decisions made by investigator judges within different criminal proceedings, but I do know the case that you're referring to, and I was discussing the circumstances with Judge Bushchenko because I'm not an expert in criminal law, but thank you for the answer. And what are or who are the judges afraid of when making or not making a specific decision? Who or what are the judges afraid of? Thank you for this question. You, as a judge, must be aware of the answer. As far as criminal proceedings are concerned, it's not a secret that in criminal justice, sometimes we can see some use of influence or pressure, and it's all about a judge being principled, about them being able to say no, and it may be dangerous for them because it will result in deterioration of their quality of life. They may be followed, they may find themselves in difficult situations. And how can we prevent this? It depends on the will of our top authorities. If they want to change something, if they want to fulfill their electoral promises, then we can change something. What we as judges can do is change the system on our level. The HQCJ can change something on their level. The HCJ does it on their level. Yes, thank you. That's clear. You're probably the only candidate who starts counting the judicial reform starting from the year 1992. I believe that the majority of candidates name a different date.
Коли закінчиться судова
So, Roman, can you please tell us when will the judiciary reform come to an end?
Що для вас буде об'єктивним
And
показником
what
того, що вона
will be
закінчилась?
an
Вона
objective
більше
indicator that the reform is over and we don't need it anymore? You wake up one morning and you realize, yes, the judicial reform is complete. When will it happen?
Дякую за запитання.
Thank you for this question.
Я можу тільки сказати, що ніхто в Україні
I can only tell you that no one in Ukraine knows the answer to this question.
Я не прошу вас там гадати на цьому кришталевому шарі.
Well, I'm not saying that you should be a fortune teller here, but What is your
для себе це
opinion?
сконструювали. Тобто це ж не якийсь момент в часі. Я
So
насправді
it's
теж
not
цього
a
не знаю.
specific point in time, of course, because I don't also know a particular day.
Судова реформа закінчиться тоді, коли
The judiciary reform will be over when we don't have laws passed in the interest of specific people, specific
зараз у нас відбувається,
timelines,
того, що
specific procedural timelines, because we've had some amendments introduced to the laws which results in the fact that nobody can clearly calculate the procedural timelines. And as a former investigator, I find it to be a catastrophe. Under the Soviet criminal procedure, we had clearly established procedural timelines, and nobody asked those questions on how to calculate them. So everything was put in clear words. But with us, criminal proceedings are being destroyed because prosecutors intentionally or unintentionally miss the deadline for sending this or that document.
має бути в межах досудового розслідування.
But it is clearly mentioned in the legislation that some of these things should be done as part of pretrial investigation. I understand that you are mentioning the quality of laws, and luckily it doesn't really depend on judges. But what should happen in the judiciary, in the judicial community, so that you realize that the reform is over?
Розумієте, я дякую вам за запитання.
Thank you for this question.
Справа в тім, що у нас, я буду казати відверто, можливо, це
I'm going to be really honest here. Maybe I'm going to go against a taboo, but
залишилося з радянських
we have very many things that we've inherited from Soviet Union. We have this sign of the signs of Soviet system. We have the shape which is democratic, but the content has some Soviet things.
ми читаємо там, як човен має, яким курсом поїхати. Цього не повинно
So
бути цивілізовано.
I think that we don't need to have this if we want to be a civilized country. Thank you for your answer. It's clear.
For the questions.
I have.
No further questions.
Пане Роман, не знаю, чи буде ви жалкувати про те, що
Roman,
що суддя прокурор
maybe you will now have to feel sorry for saying that a judge is a slave of the law, but still.
закон дійсно важливий.
Yes, the law is indeed important when you're making your decisions, at least within the system where you are working, where I'm working, and where all our colleagues in Ukraine are working.
Закони бувають різні.
We may have different laws,
Самі сказали, що
and as you said, mentioned the quality of laws leaves much to be desired.
крім того, наприклад, в Третьому рейху були
In addition, in the Third Reich, there were laws according to which you could burn people based on their national origin, and it was considered lawful.
що краще було б поставити
Don't you think
пріоритет
it would be better to have the rule of law as a priority and not
яку застосовуєте ви як суддя
the priority of legislation
кримінального напрямку, кримінальних це не
when we are talking about criminal proceedings
суддя, який практикує
that you are working with?
Я з вами цілком погоджуюся.
Yes, I totally agree with you, and thank you for this question.
Верховенство права. Я не
I agree that it should be the priority of the rule of law, and I mentioned that report of the year 2011 on the rule of law, the report of the Venice Commission.
Венеційська комісія
And
дає
the Venice Commission
верховенство права.
sets out 8 ingredients of the rule of law, and the first ingredient is the quality of law, and I can quote, the law should meet the criteria of clearness, predictability, and understandability. And if a country doesn't have laws that meet this criteria, it de facto violates the rights and freedoms of the people. And with regards to that law of the Third Reich that you've mentioned, I can tell you the following. Laws are regulators of relations in the society. Back in the day, we know what kind of relations existed in Germany. That is why the laws reflected the Nazi regime and the aspirations that the Nazi government had. And it should also be mentioned, there's this quotation of Jean-Jacques Rousseau, who said that a wise lawmaker starts not from adopting a law, but from studying the aptness, the fitness of this law for this very specific society. In simple words, the law should reflect societal relations. In this way, it can regulate these relations. Thank you. You've also mentioned that for quite some time, mass media has been bullying the judiciary. Well, I understand that this is maybe you expressing your personal opinion. Yes, on many occasions, mass media has been critical of the judges and the judiciary. But you cannot but agree with me that we are working for the public, and coverage of our work in media is one of the most important contributors to the restoration of trust in the judiciary. Because closeness of the system has never resulted in enhanced authority of judges and courts. How do you think? Perhaps we need to improve on the quality of materials published by the journalists, or maybe improve the level of communication done by each specific court, without generalizing the activities of the media. Thank you for this question. I think that we need to improve on the qualities of journalists, on their integrity, because I was a victim myself when I made a lawful decision in the case of murder of lawyer Ihnatov. And in the courtroom, we had practically all the lawyers of Kyiv region present, the Bar Council of Kyiv region. So all those lawyers, they recorded the proceedings, they heard the questions asked which could not be answered. And apparently it was an unlawful decision, and a person was detained on an unlawful basis. But somebody ordered an article. I will not be mentioning the name of that person for ethical reasons, and there was this piece shown on one of the TV channels. So it was mentioned that a notorious panel of judges, I don't know why we were mentioned as notorious, but it was said that we released a murderer, that we let a murderer go. But we acted in accordance with the decision of the Constitutional Court, and we referred the case for additional procedures. So there was no Article 422 back at the time. And we were using the recommendations of the Supreme Court while making this decision. Yes, it's clear. So when you told us about bullying from mass media, I felt that it was your personal experience. So maybe we could counteract some of these journalist activities. Articles published by journalists for money, commissioned by someone, this is a thing that exists in this society. Yes, we do have a certain percentage of such articles, but at the same time, Maybe we could use judge speakers to refute the claims, to express our opinion, to circulate those statements that you've just mentioned, to make them known to the public so that we can confirm our position, so that we don't have this conflict with journalists, because in this conflict we will always lose. Yes, I agree with you, that's what we did. After those news pieces appeared, that's what we did. We put up information on our website and we refuted all the allegations. We did it in a civilized way. Yes, of course, we responded. Let's not focus on these specific statements, but let's theorize a little. Don't you think that the criteria of experience of working as a judge should be decisive when the issues of promotion are decided? Or maybe we should leave the Soviet heritage behind and consider their integrity and potential professional accomplishments, other than the number of years that they've served as a judge. What should you consider a priority? I think that experience is a priority, experience and professionalism. And you can gain this experience not just while working as a judge, but also while you're working as an attorney at law, when you're practicing law, or when you're doing some research work. And a bright example are researchers who are members of the Supreme Court, who are judges of the Supreme Court. And it's really interesting to read the decisions of the Supreme Court, because these decisions are really profound, which is not always the case with other courts. I really like the decisions of Justice Bushchenko. I may disagree with him on some occasions, but it's interesting for me to read his decisions. So I think it's not just about the judicial experience that should be considered. Thank you, Roman. That's all from my side.
No?
Пане Романе, наша співбесіда добігає
Roman, your interview is coming to an end. How would you like to summarize it? What would you like to tell us at the end of your interview? If I may, I will quote Taras Shevchenko, "Fight and you will win and you'll be helped by God." I would like to address our candidates and Ukraine, the people of Ukraine. I'm sure that we will win and we will build a civilized Ukraine and everything will be fine for us. I believe in it. Plus, I've had this test in my past. And I would like, in passing my regards to our eastern neighbor, mention Taras Shevchenko, that we in our country have our own laws, have our own truth, and they shouldn't be coming to our home trying to impose their own views on us. We will decide by ourselves how we want to live and what country we want to build. And we will prevent them from advancing further into our country and trying to take control over us. Thank you. Thank you for this interview. That's the end. All the best to you. Take care and goodbye. Thank you. Thank you.